Tuesday, March 28th, 23.
Okay, I'm going to wait till the feed starts and I see it on my screen, and then I'll continue, Mr. Chairman. There we go. So, Mr. Chairman, members of the commission, this is a meeting of the Ethics Commission for a special meeting and hearing to deal with a complaint. And I can't see the whole commission, so could you guys, identify yourselves so we know who's here?
Steve Marsalek.
Richard Ott.
Linda Canfield.
Great. Okay, so I'm going to give you a little overview of what's going to happen today and see if it meets your approval, and then we'll go through some of what we need to happen. So last week, during our normal ethics committee meeting, it came to our attention that a complaint was filed by an individual in the town against one of the candidates running for mayor. That complaint was received and reviewed on 3/20. However, since it was not part of your agenda, nor was notice given to anyone involved in the complaint, it was not discussed at your meeting. Subsequent to that meeting, we received a follow-up or second complaint from the same individual. That one was dated March 22nd. It dealt with largely the same facts, and so it is the subject of what we're going to deal with today. So that is the subject of what we're going to deal with today, and here's the legal background of how we're dealing with things. The Ethics Commission is created in the Taneytown Code under Chapter 16. Chapter 16 talks about the duties of the Ethics Commission. It talks about conflict of interest provisions that the elected officials have to deal with. It talks about the financial disclosure forms that have to be filed by the elected officials and the candidates. Those are the things you dealt with at your last meeting. Chapter 16 lays out an investigative procedure for complaints. It deals with how hearings are held and all the minutiae that you would think with if somebody wanted to make an ethics complaint. However, all of those issues that can be complained about have to deal with the things that are in Chapter 16, the ethics provisions. The complaint that we received, while it talks about general principles like ethics and fairness and transparency, the actionable things that it is talking about are related to complaints of the campaign finance laws. Now, your group also looks at the campaign finance laws, so the Ethics Commission is in charge of looking at that, but your authority to look at that comes from Chapter 18, not Chapter 16 of the code. And that distinction is important to remember because the penalties and the actions and the procedures are different from one chapter to the next. So to give you an example, so we're very clear, in Chapter 16, the Ethics Code, it says the board may investigate complaints related to this chapter, meaning Chapter 16. In Chapter 18, the Campaign Finance Code, there is nothing in there about how you do investigations. All that is in there is what is required, how the forms are filled out, and there is an enforcement and penalties section. So it's clear that there's two different sections. Because Chapter 18 does not have specific procedures, the first thing I looked to was state law and see, does state law under its campaign finance rules apply here? And it's a pretty quick look because state election law and state campaign finance rules do not apply to municipalities. So we can use them to guide our discussions to say, what would the state do? But we are not obligated to follow them. There's no magic bullets in the state law. So then the next thing that I turn to, since there's no state law, I turn back to our Chapter 16 and say, how would we handle this, the Ethics Commission handle this, if it were an ethics complaint under Chapter 16? And that provision is pretty clear. Basically, you do an investigation. After your investigation, you hold a hearing, which is closed to the public under the closed meetings, under the Open Meetings Act. You can close that meeting to the public. At the end of that, you come up with a finding, like a judicial body, and then we would have an opinion written. I would write you a written opinion that you would agree to, and that would be the finding. So to compare it to like a court case, you are the judges. There isn't an adversarial, there isn't a one plaintiff and a defendant. There is simply an issue that you're going to have testimony, look at information, and at the end of that, you will then make a decision. So that's kind of how this goes forward. How this differs from the state law, to be very clear, is the state law, if a complaint is received and it's found to be substantiated by the state election board, it is turned over in the form of a complaint to the district court. And then the district court handles the entire operation at that point in time. We don't have that luxury. So that we're all on the same page of what's at stake here, your authority under Chapter 18 is very limited as to what you can do if you find violations. And you can do it like in two different menu sections here. The first menu, and these are not exclusive, you can pick one or all. But Chapter 18 basically says that you can deal with civil penalties. It doesn't use those words, but civil penalties, meaning you can issue fines, and the fines on there are limited to up to $500 per violation. Or it issues criminal penalties. Now, obviously, you can't charge somebody with a crime. That is beyond the authority of the town. But since a violation could be held as a misdemeanor, you can refer the matter to the Carroll County State's Attorney, and then they would handle it whether they feel they could prosecute this or not. So that's the range of what you have. To be clear, there is no option for you to say to a candidate, you can no longer be a candidate. There's no options for you to do that. You have a third option in conjunction with the other two. Consider it like an equitable option. And what I mean by that is it's not clearly a fine and it's not criminal. It's fix the problem. So it could be something as simple as fix the forms, which we've done before, fill out the forms correctly. But it could go beyond that. It could be fix the forms and give the campaign contribution back. Fix the forms and open a bank account so you can make them do things to comply with the law. All of your actions to make somebody do something could be enforced by the Circuit Court of Carroll County, meaning the city would go and get an injunctive order to order the candidate to do that if they didn't do it on their own. So that's the tools in your toolbox of what can happen. To anybody giving testimony, because you will eventually be getting testimony today, there are certain things that these people need to be in mind. First of all, this is not quite a Miranda warning, but if you're familiar with Miranda warnings, that is what the police say to you when you get arrested, that anything you say can and you will be used against you. Because the possibility exists that there could be criminal action pursued after this based on whatever finding, anyone testifying needs to realize that what they say in this is not protected and could be discoverable and turned over in any criminal prosecution. And any witness testifying is considered to be testifying under oath. So in the event that they are found to be fraudulent or misleading, that too could be prosecuted as perjury. And again, we don't prosecute it, but we turn it over to that. So this is a matter of a very serious nature, and the people who are involved in this need to remember that as well. So with that said, I want to tell you how the state election law breaks out potential penalties. I know it's like doom and gloom, but I want you to know what's at stake here before we ever start. The state law is under election law, the election law article, and if anybody wants to go look up later, it's election law article section 13603 and beyond that. And they break it out into two areas. They're not quite simple, but one is criminal and one is civil, just like I've laid it out for us. The criminal area, they usually reserve that when they can find that the conduct that the complaint is about, if substantiated, is knowing and willful. So there is I don't want to get too lawyerly on you, but there is a mental state associated with this conduct, meaning I knowingly did this, I willfully did this, and therefore they say, well, that could be criminal in nature because the forms are signed under the penalties of perjury. If they find that it's a mistake, a lack of knowledge, meaning in legal parlance, there was no mens rea attached to this, no mental state to do this, then it usually falls in the civil realm, meaning just because you made a mistake, it doesn't mean anything like that. To give you the best example, it's like speeding. Okay, it doesn't matter if you intended to speed or you did not intend to speed. If you are exceeding the posted speed limit, you are going to be found of a civil violation. But if you do things when you're driving your car intentionally, like recklessly, or drive over things, then there's more of a criminal violation associated with that as well. So it has to do with somebody's state of mind. While you can find their state of mind, your finding is not final. Remember, this still, if it would go criminal, would have to go before the state's attorney, and they would be the ones who have to prosecute this, and then the court would decide. So all of that said, we're going to be discussing these things in very fine detail, but that is where we head with this, okay? The last thing we haven't talked about is federal election law. And federal election law, to some extent, applies, meaning there's no section you can go to and say, how do you fill out these forms in federal law? But federal law applies to all elections. You can't discriminate. There's certain requirements for voting and not voting and things like that. And so there are certain aspects of federal law that I will brief you on if it becomes relevant to our discussions as we move forward. So that's the legal foundation. Is there any questions that you have, Mr. Chairman, members of the committee?
No, I have none.
No.
Okay. So what we're going to do here, this is the first time that this group has dealt with it. We're going to kind of shadow what Chapter 16 does. Remember, I told you Chapter 16 doesn't apply, but we don't have any guidance. So we're going to try to go with what we have in our code as a guide. And Chapter 16 basically says that you all do an investigation. And if you find that the investigation warrants a hearing, then you can have a hearing. So for my purposes, I felt that when you looked at the forms last week, you received a complaint that's on its face had problems with some of the numbers that were on the forms. That was as much of an investigation as you're probably going to get without having more information. So that led me to, we're going to hold the hearing. That's today's event. Chapter 16 says that all hearings are closed to the public. So that way you basically taking ethical testimony. The state law allows a public body, which is you, to close meetings under provisions of the Open Meetings Act. And the one that we'd be using today is closing it for personnel business. And I'll be reading you exactly what, or the clerk will, one of us will be reading you exactly what that means. So the logistics for the members of the board and the members of the audience is, this is the open portion of the meeting. We will shortly ask the board to make a motion to close the meeting. We'll state the reasons why, and then the meeting will be closed and the public will be excused. We will not again meet in open session. So the board will then close the meeting, meet in closed session, take witness testimony, have deliberation, and if they so decide, come up with a decision that will later be memorialized in a written opinion. But that written opinion will be public. So that is how the public then finds out. Kind of like a court case again, same type of deal. So that's the procedure. We're going to ask that we didn't issue subpoenas, if you will, but we issued invitations to key people we thought should testify. And that would be the subject of the complaint and also the individual that was involved in making the contributions that are at issue. So you'll have those two witnesses that at least will start off our discussion. And then we have a bunch of documentation, written documents to hand out to you when we get into closed session. Any questions about the logistics?
No, I have none.
The closed session is going to occur downstairs in the conference room. So when you are finished and close the meeting, we will stop this link and stop the telebroadcast of this. You will leave. Clara and Jim will take you downstairs, go into the back conference room, and we'll reconvene at that point in time. Any questions about that?
Nope.
Okay, under the Maryland Open Meetings Act, we're going to get right to this then. The presiding officer must read a statement about why we're closing the act. Clara has that statement in front of her, I believe.
Actually, Jay, I do not have that in front of me.
Okay, I have it in front of me, so stand by here. Hold on here. So, Mr. Chairman, with your permission, I will read the statement in its entirety since I have it, and it will suffice as this is coming from the board. City of Taneytown presiding officer's closing statement under the Maryland Open Meetings Act. Given this March 28th, 2023 at 3:20 p.m. in the City Hall, the citation and purpose of closing this meeting in accordance with the Maryland Open Meetings Act is Title 10 Government Procedures, Subtitle 5 Meetings, Section 3-305B. This meeting will be closed as for business for 1, to discuss the appointment, employment, assignment, promotion, discipline, demotion, compensation, removal, resignation, or performance evaluation of appointees, employees, or officials over whom it has jurisdiction, or 2, any other personnel matter that affects one or more specific individuals. So off script, the reason we have jurisdiction over the candidates because they have to file. Therefore, it is to discuss the discipline, demotion, compensation, removal, yada, 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 over officials we have jurisdiction over. So that's the reason we're doing it. The following is the list of topics to be discussed, and we will only be discussing these topics, no other topics at the meeting. The citation is, again, 3-3057, an ethics complaint to obtain legal advice about the violation of the Taneytown Campaign Finance Ordinance and hear testimony and other hearing matters related to complaint under the Campaign Finance Order. So with that, a motion needs to be made to close the session from one of your members.
I'll make a motion to close the meeting.
And now it needs to be seconded.
I can second it.
Okay, we have a motion and a second. Now we need a vote. All in favor?
Aye.
Okay, we have unanimously, and the statement was made at 3:21 on behalf of the presiding officer. So with that, Mr. Chairman, if you would get your belongings and follow Clara, and the staff will direct the people who are going to testify what's to happen, and I will see you downstairs.